file me check, which I cannot because my financial condition does not permit. My lord, now I am behind the bar 78 days, my lord. Through my information, CD has not come.
CD not received today. Moreover, my lord, they made informant as a
Yes, she has been made party.
notice cyber not
I just served. We have sent it.
maybe in the record.
And 98 days is the statutory period, madam. There is no evidence of 76D, madam. Of course, that's why, madam, CD ought to have been come, and it has not come, madam. So, accused must get the benefit of 78 days statutory detention, madam.
No, we have to peruse the case.
Beg your pardon?
We have to peruse the case.
Very true, my lord. But on the face of the record, my lord, is it a believable story that wife, a husband will see the gang rape of the wife in front of her? Which is unbelievable story.
Many unbelievable things are happening.
Very true, my lord. But he was not with me. My lord. Even the vehicle was detained, but the driver was
Okay, let us see. You have taken steps for
informant.
serving. There is no office note.
It has not come for probably.
Heard Mr. S.C. Biswas, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary. Stop. Prayer is allowed. It also appears from record that though notices were issued to the victim through jurisdictional police station, however, service report has not yet been received from the concerned police station. The registry to issue reminder.
Fresh step of opinion type is.
No,
Why to
fresh
take
step
step again?
is not necessary.
It is available in the record earlier, I think.
It has to go through
Possible. Possible pace.
today is 14/11. You have taken steps on 9/11. We have to wait for
Service report.
service. Await service report. No, and Mr. Gogoi,
Lord,
you may, because this notice has to come through you.
yes, they have to take step before registry, then registry will send it to our office, then we will send to police station.
They have sent it to the
Our
office of the
office.
public prosecutor.
Then I'll take care of.
You also try to contact the concerned
I will.
police station.
Yes.
And find out the
Yes,
status.
yes.
Learn it. What it will ask me. Stop. No. Registry to issue reminder. Learned additional public prosecutor is requested to take necessary information regarding service of notice on respondent number 2 from the concerned jurisdictional police station. Stop. When
May I pray for
21, 11.
20th. Better 20th.
Monday no logo.
Monday no hobo.
Monday problem hoy ki ahi paunte
Oh,
ki.
21st.
fix 21/11 for case diary.
Different.
Item 7,
May I please?
Five to the reply. Good news. Yes.
May I please, Lordship? Madam, here in this case, I am behind the bar since 33 days. Initially, I have been shown arrested here in this case. My lord, initially I was arrested in Sonapur PS case number 208/23. My lord, in that case, I have been granted bail. My lord, kindly for a moment, page number 16.
Page number
16, 16. On the motion, it says itself granted bail, my lord.
Today, my lord, diary not received.
Well, that is correct, my lord, diary not received, but my lord, kindly for a moment, FIR is at page number 8. The FIR was lost on 8/8/22. While I was inside the jail, the investigation agency shown arrest in the instant. Date of FIR is, my lord, page number 10, my lord, original one, my lord, page number 12, relevant person, my lord. FIR was lost on, my lord, 8/8/2022, 22, my lord.
since when you are detained behind the bar?
Here in this case, my lord, initially arrested on 2/10/23, my lord. 2/10, 2nd October. Here in this case, my lord, I have been shown arrested on 12/10, my lord. Nothing recovered, my lord.
No, we have to peruse the case.
My lord,
Heard Mr.
kindly on 17,
A.
my lord.
Parmani,
This is
learned
from
counsel
Dr.
for the petitioner. Though the case diary was called for, however, an additional public prosecutor
21.
submits that
Kindly
same
on
has not
17.
arrived and
17.
prayed for
Otherwise, can you?
producing the case diary on another day. The prayer is allowed.
21.
17, my lord. Kindly on
17 is
From
Friday,
Gossip,
my lord.
Yes, because last more than 10 days elapsed, my lord.
17, we may fix it, my lord. I do not know.
Take a chance, my lord, on 17, my lord.
Yes.
Let this matter be listed again on 17th.
Highly.
Item number 5, timing matter.
Now, if he has not gone through, call other.
No, no.
He-
I say.
My lord, after some time,
Okay,
senior has not come. Okay.
Timing item 30.
May I please, your lord, matter will be taken up tomorrow.
okay. On request of this, on request of Mr.
Hussain.
D. Hussain, learned counsel for the petitioner, let this matter be listed on 15/11/2020.
Obliged.
Item number 9, bail hearing.
Please, your lordship. That's a diary not received.
Lordship, otherwise, Lordship, I have.
You are on interim bail.
I'm enjoying the interim bail, Lordship. Lordship, otherwise, this is a very complicated case which has been heaped up on me, Lordship. And the FIR, the FIR.
Have you appeared before the IO?
Yes, Your Honor. Yes, Lordship, I have appeared before the. Has complied with all the conditions.
Let us give one more chance.
Lordship.
Heard Mr.
PP Medhi, Lordship.
P.P. Medhi, learned counsel for the petitioner. Also heard Mr. D. B.B. Gogoi, learned additional public prosecutor, who submits that the case diary which was called for has not arrived and prays for another date for producing the same. The prayer is allowed. We let this case be listed again on
Interim is there, my lord, 30/30.
30/11. The interim order shall continue till next meeting.
Item number 12,
Right, Your Lordship.
Well, diary not received.
May I please, your lord. My lord, as per my information, my lord, target has been terminated and he received notice from the trial court, my lord, for appearance. And it was fixed on 12/12 for appearance.
Withdraw.
Okay, whether you were on interim bail,
Interim. Lordship.
have you appeared?
Appear, my lord.
Heard Mr. H. A. Ahmed, learned counsel for the petitioner, also heard Mr. B. B. Gogoi, learned additional public prosecutor, who submits that the case diary which was called for has not arrived. However, learned counsel for the petitioner has submitted that in the meanwhile, charge sheet has already been laid and he and the petitioner has received the summons from the learned trial court. It is also submitted by learned counsel for the petitioner that the petitioner was granted interim anticipatory bail on 29/8/2023. And in pursuant to the directions of this court, the petitioner had appeared before the investigating officer and has cooperated with him. Considering the submissions made by learned counsel for the petitioner, the interim anticipatory bail granted to the petitioner Kundan Kumar Patel by order dated 29/8/23 is hereby made absolute, subject to the condition that the petitioner shall cooperate in his trial. Ready যদি হইতে
Five.
Okay, madam, I mean, other court, my lord. This is the case, my lord, the 376 is there, but both are major. The present petitioner is a police constable, a married person. She is unmarried, my lord, and it is one-way traffic, my lord. She wanted to have relation with me, I denied. So this is the reason why.
You
this-
are police person.
I am the police person. I am a married, having children also, my lord. But somewhat in a marriage
since when-
ceremony,
Since when you are in jail?
I am in jail since 28/9. Today is 48 days, my lord. 28/9/23. Arrested, my lord. So whether further custody, I am only at this stage, further custody is required or not, my lord. You also can see the FIR, my lord.
Where is the affair at page?
Yes. FIR is page 13, 12. The Department of Shock has also given to me. I also replied to that also, my lord. I am now under suspension.
You are under suspension.
Yes, ma'am. So this is the one, another ground for consideration of my bail, my lord. Page 12. With organized subject, I would like to inform you that I lodged an FIR before the OC on 8/9/23, alleging some materials against the named accused person, Raqibullah Ahmad, that my younger sister, namely Shamela Khatun, was missing on 5/9/23 while she went to meet an interview at Barpata Road. She stated to me that she was kidnapped by the aforementioned accused person on the midway of Barpata Road to Howdy town and kept her in a hidden place and raped her forcibly against her will. The above noted accused person kept her in a closed room, feeding drugs and forcefully so and so on several times. Later on 9/9/23, she was carried out by the four-wheeler car and left her in a Bahari hut near Bahari Samabaya Samiti Limited, Tarabari, while she was almost senseless. Nearest villagers had seen the victim girl lying on the roadside and informed the police of Tarabari by pedestrian. As soon as the police of Tarabari recovered her and admitted. So later on, the victim girl, Shamla Khatun, was released by the help of the police of Tarabari and sent her to take rest to her parents' home. And OC suggested me to come again in respect of PS for recording her statement. It is a fact that I rushed to the respective PS with my younger sister on 11/9/23. But the IO of the case did not inquire, your lordship can inquire about the facts and circumstances. He only said that it will come into force later on. Today, 18/9/23, I with my younger sister visited the police station and earnestly requested to take a statement. But IO does not pay any heed to it. Even he misbehaved us and the case is not proceeded as finding no alternative, I am going to appear before your honor with my younger sister, before your honor to enjoy legal justice about his fact and kind. My translation is not happily done, my lord. Oh, it is English, my lord. FIR is in English, my lord. Legal action against the named accused person and be taken a smooth action against so and so, so and so, so and so. So registered under section 376, 360, 365. Now your lordship kindly see, forwarding report page 17. Page 17.
Yeah.
Accused person, namely, my lord, two persons are here, my lord. One is nothing, no whisper against him, but he is simply sister's husband of the petitioner Bhagavan. Your lordship will find that grounds of arrest. This is a heinous crime of rape. Accused person, namely so and so, held a police personnel dubbed the victim by giving her fake promise to marry her, though he was a married person. He kidnapped her and kept her in a room. So and so. The accused person named Ghulam Hussain, who was the friend of the accused, that is petition number 2, was helping him in committing the crime. He helped him in this crime by carrying out the victim from so and so, so and so. Then unless such persons are arrested, they might flee away. He is a person, a constable, government employee, cannot question the flee away, my. If the arrest person is not released at this stage, it will go to the faith of public on so this is another thing. So then you'll have at page 19. I was given a shocker's notice and I submitted it. He replied how it happened and what is the case behind that, man. To my authority. Page 19, your lordship. That was submitted. Shocker's reply, mother. Details I have given her. Actually, she was my daughter. It is not a fact that I have kidnapped the girl named so and so from Howdy. In fact, I remained present at my platoon headquarters at so and so business on 5/9/23. I did not go to Howley or Borpeta Road on 5/9/23. And the question of kidnapping the said girl does not arise. I do admit that so and so had habitually contacted me over mobile phone and expressed love and affection towards me since last few months. And not only that, but she had also requested me over phone to marry with her. In response, I told her that my marriage could be arranged by my father, where I have no choice. But she did not convince of my request and come to Derukamari at around so and so, where she contacted with me over phone, and I came to the place where she was waiting for me at about so and so. When I contacted with her at Derukamari, I found that she was in abnormal condition and asked me to marry her. Otherwise, she would commit suicide in my presence and threatened me that I should be facing the consequences of so and so. So these are the things, madam, I have explained everything, madam. Now I am only, madam, whether both are major, madam. She is over 25 years old, madam. Whether further custody is required, I am only on that, madam. That one is subject what my learned friend says, madam.
Yes, the ID receipt, my lord. 164 statement of the victim reported. She implicated 376 against number 1, not against number 2. Number 2, my lord, who was happened to be a friend of the number 1, he supplied the medicine bottle, my lord. That was pure to victim, then she became chanceless. That is the material here.
The allegations are very serious.
Number 376, madam. Now, madam, you have lost a kindly see a lady of 25 years old. She is, madam, following me all along, madam.
No,
Yeah.
that is your submission.
No, my submission, but 376, if it is there, it is there with the concern. If it is, I am not, my learned friend, I am, whatever he is there enough, my lord. If it is in the city, my lord, naturally has to, because she wanted to implicate me, she wanted to get me inside the jail, my lord. So naturally, this type of allegation will be there, 164. Now, since it is 439, my lord, it is not 438, my lord. I am only at this stage, my lord, only length of detention, my lord. Whether anything will be done, my lord, any purpose will be served, my lord, by keeping him in jail further, my lord. Only on that, my lord. I am under suspension also, I can't do anything, my lord. I cannot give it there. I cannot flee away because suspension, I am to report to the my lord headquarters frequently. My presence can be assured, my lord, by any condition your lordship may give. He needs further custody or not, my lord. Your lordship may ask.
Yes.
Further custody required or not, my lord. For what purpose? I am only at this stage, my lord. Whatever happened, my lord. It is a very unfortunate incident, my lord, rightly or wrongly, my lord. it is.
I'm not inclined.
That's true, my lord. Normally,
I'll
But-
go through the case diary.
but that is up to your worship, madam. But only it is not 4:38. I am only on that at this stage, madam. I'm not
Okay.
saying, madam, he is free from anything, madam. There may be something. But further custody, whether it will serve any purpose or not. That one they have. Ultimately, he will get after minus 1 month or 1.5 months. Ultimately, he will get.
No, but you were in police. The question of.
That is that when
intimate-
somebody is following me, madam, what can I am a human being, madam? That also your worship see, madam. Yes, I may be police, madam. At the same time, I'm a human being also. If somebody is consistently following me, is consistently
And
pressurizing
in
me.
this case, actually, the FIR was not registered when the brother of the victim approached the police station. It is
So,
only
sir,
after
That is
lodging a-
allegation, one of the allegation is that against the inquiry, police also, madam. So police might have known that, yes, it is a false case. So they have not registered the case. This is one of the reasons of getting.
this
bail.
may be one of the reason, one other reason that they are from the same profession. And therefore,
Nowadays, your worship, SP, DIGs are being taken to custody, madam. Nowadays, these are very small personnel, madam. SPs are in jail, DIGs are in jail, madam.
what is your submission, Mr. Kopat?
Lordship, his
That-
involvement, my lord, that is admitted,
Yeah.
my lord.
Now length of only, madam.
That 376 allegation is number against number 1. That is not against number 2.
That is there, madam. I am not denying, madam, if it is there. Now further.
Voter measure victim 25 years, that is all that some relation was there, my lord, because if he gave hope of service, my lord, that is to victim. On that,
No, you make submission whether further custodial detention is necessary.
no, that I cannot say, my lord.
You-
Only what is the material there in the diary, that the material is there against him, my lord, that is 376 material is there, number 1, against number 1.
But statements already recorded, madam. Because she is the main person, her statement is the main person. That is already recorded, madam. Nothing remains to be investigated so far this victim is concerned.
What information investigating officer has given to you while
No, what
There
is
is
the
no-
material against him, my lord? That is investigation they have done. The material is there against him, my lord. He is registered under 376. That is against number 1, my lord, that material available in the diary.
heard Mr. H.R.A. Chaudhary, Learned Counsel for the petitioner. Learned Senior Counsel for the petitioner, assisted by Mr. M.I. Hussain. Learned Counsel for the petitioner, also heard Mr. B.B. Gogoi, Learned Additional Public Prosecutor. Mr. Gogoi, I wanted to know from you on what ground you-
Under detention is required.
you are opposing, you are otherwise opposing the break.
Yes, my lord.
On what ground?
The other detention. My lord, he may repeat it and he may threaten that victim informant side, my lord, if he will be released on bail.
This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioners Rakibul Ahmed and Ghulam Hussain, alias Ghulam Hussain, who are detained behind the bar
Since
Since
29/9/20.
29/9/23 within brackets since last 48 days in connection with Tarabari PS case number 76/23 under section 365/368/376 of the Indian Penal Code. The gist of accusation against the present petitioners is that on 18/9/2023, one Omar Khan lodged an FIR before the Superintendent of Police Borpeta, inter alia, alleging that his younger sister, within bracket, victim of this case, bracket close, was missing from his residence since 5/9/2023, when she went to appear before an interview at Borpeta Road. Later on, she informed the brother of the she informed her brother, that is the first informant of the case, that she was kidnapped by the petitioner number one, by the accused Rakibul Ahmed, who is the petitioner number one in the instant case, and she was forcefully administered some drugs and was repeatedly subject to forceful sexual intercourse. And thereafter, he was recovered on a roadside from the villagers. Stop. It is further alleged in the FIR that the that the informant had rushed to the concerned police station immediately after the incident. However, the police did not help him, and even after lodging of the FIR and recovery of the victim girl, police did not record the statement of the victim girl initially. Stop. After receipt of the said FIR, the superintendent of police directed the additional SP crime to supervise the matter, and he charge of Tarabari police station to take appropriate action on the FIR. Learned senior counsel for the petitioner has submitted that the victim girl is also a major girl, No, the victim girl is not a minor, and she is of what age?
25.
25 years of age. It is also submitted by learned senior counsel that the allegations made against the present petitioner in the FIR are false, and it is further submitted by learned senior counsel that the petitioner number one has already been suspended by his department, and
So far notice was issued, reply also given, proceeding also started.
and a show cause notice has been issued to the present petitioner. to which he has also replied, wherein he had stated that the victim girl used to habitually contact, we used to regularly contact the petitioner number one over telephone and used to express her love and affection toward him, and also pressurized and also requested him repeatedly to marry her. So, Learned Senior Counsel has also submitted that considering the length of detention already undergone by the petitioner, they may be allowed to bond bail. On the other hand, an additional public prosecutor has opposed the grant of bail to the present petitioner and petitioners and has produced the case diary of Tarabari PS case number 76/23, which was called for in connection with this case. It is submitted by learned additional public prosecutor that there are sufficient incriminating material that the petitioner number one had subjected the victim girl to physical sexual intercourse, and petitioner number two helped the petitioner number one in committing the alleged offense by procuring the drugs which were administered to the victim girl. Learned additional public prosecutor has also submitted that considering the nature of allegations and the nature of offense involved in this case, there is every likelihood that if the petitioner is released at this stage, he may try to influence/intimidate the victim girl as the investigation is not yet completed. So I have considered the submissions made by the counsel for both sides and peruse the materials available in the material available on record, including the case diary of Tarabari PS case number 76/23, as well as the statement of the victim girl under section 164, recorded under section 164 CR. Though both the petitioners have already undergone 48 days of detention, which otherwise is a long period of detention. However, considering the fact that the petitioner is a police personnel and is involved in a heinous offense, like in heinous offense of repeatedly subjecting the victim girl to forcible sexual intercourse, and as the investigation has not yet completed, this court is at this stage not inclined to grant the bail to the present petitioner at best.
That is number one, my police. Other one, there is no allegation.
No,
That's my PP, man. No allegation.
No, but you helped in kidnapping and I'm not in.
376 is not against him. As he,
No, that I have observed, that I have observed. So for above reasons, the prayer for bail opposite petitioner. Thereby send back the case.
obliged.
Lordship, the charge was filed on 24th of July.
24th July.
Yeah, the bail petition was rejected due to as the allegation sufficient materials have been found and there may be enmity between in the parties in their locality and some temper the
Where is the bail order?
bail order I have not accessed in this record. I have seen in the court's record online.
Dated for that document.
Dated 2nd of June
26.
20.
Which date? 26.
26/23.
Where is the FIR?
Page number 9 to 15. Vernacular is page number 15. May I read now?
Yeah.
এজাহাৰকাৰী বিনীত নিবেদন এই যে ইংৰাজী চয়নটো তাৰিখৰ ৰাতিপুৱা 9 মান বজাত মই মোৰ ঘৰত প্ৰকল্পতে থকা অৱস্থাতে উপৰোক্ত আসামীজনে অনাধিকাৰ মোৰ ঘৰৰ ভিতৰত প্ৰৱেশ কৰি পিছফালৰ পৰা মোক সাৱটি ধৰি মোৰ মোৰ মুখত থোপা দি টনা আজোৰা কৰি মোৰ ইচ্ছাৰ বিৰুদ্ধে জোৰ জবৰদস্তি মোক ধৰ্ষণ কৰা উদ্দেশ্য তাৰ গুপ্তাংগটো মোৰ যোনিত সোমাব চেষ্টা কৰাত মই মোৰ আত্মৰক্ষা ও মোৰ জীৱন বচোৱাৰ বাবে মোৰ টেবুলৰ ওপৰত থকা ব্লেডেৰে আসামীজনৰ গুপ্তাংগত আঘাত কৰো গতিকে
Let the victim girl be examined.
Lordship, this is 376 is attempt to rape and 191 days in the return is has been detained for 191 days and I am the real victim in this case because my genitals has been chopped off and it is in swelling mode right now and I need the
Gitanjali,
better treatment and I am not getting good
live
treatment in
streaming of Kodi.
I am not getting proper.
This junior is there.
Mr. Iralu, how much time would you require?
Your Lordship, if we are to go through the evidence, the depositions of the witnesses,
No,
Yep.
actually, I have heard you at length earlier.
Your Lordship.
What I suggest you make gist of your submission. If there is some query, I will raise those queries. Instead of repeating everything again.
Your Lordship.
You may start. Mr. Longkumar is there. In the meanwhile, Mr. Jameen may join us.
In fact, if Your Lordship permits, I would like to go to the depositions of the witnesses.
No, but it will take, then we will be making our hearing very long if you go through depositions. We have already earlier at one point of time, we have gone through. If something is very relevant, you may go through it. Otherwise, what I would suggest you take half an hour, Mr. Jamir take half an hour. We will be finishing it within 1 hour.
Okay,
Maximum, that is the maximum outer limit.
Your Lordship.
And if you can wind up earlier, I would be happier.
Your Lordship.
Yes. Yes, Mr. Iralo.
Lordship, although this, Lordship has rejected the application, the IA.
Yeah.
Now, I would like to refer to the, page number 32 of the appeal memo. This is an order passed by the district judge, additional district judge, and on 31st, 1, 1986.
What is it?
This is the order passed by the ADC head.
Yeah.
Is number 48/85. And I would like to refer to the last, just before the order, the paragraph just above the order. Now, this, may I read, Your Lordship?
Yes, yes.
This case is a long-standing one. I examined the petitioner and his witnesses, Sri Vechone. It is affirmed that the land was officially sold to one GB in 1969, who again resold it to the appellant. On one occasion, GB also appeared in my court and testified that he had sold it to the appellant. The court's judgment awarding the disputed land to the third party cannot be justified and accepted. Whatever the case may be, if a third party claims comes up, it should be decided separately, and to decide this case in favor of a third party without any written complaint is illegal. So, in this court, when both the appellants, present appellants witnesses were alive, Vechone and GB period, they deposed before the ADM time. And in the depositions of Vechone, who is one of my witnesses, he has categorically stated that the same thing, that it was sold to the present appellant.
By Pire GB.
Yes,
Okay.
so, that is our main case, because the land in dispute, now, that was, during evidence. That was, the witnesses were alive, at least one. Lechone was alive. And he deposed before the court, and the respondent hearing could not rebut the positions of this witness. On the other hand, the main findings of the trial court is that the trial court relied on a document which has never been executed. And as your lordship is aware, that in the judgment, the impugned judgment, the court has said that no party has produced any documents. When no party has produced any documents to be exhibited, then how can the trial court rely on a document which has not been exhibited? That is totally illegal, Your Lordship.
Okay.
And in fact, that is my main case. And as stated earlier, I'm supposed to be the plaintiff. The application filed by me has been treated as the plaintiff. In that case, I'm supposed to be the plaintiff.
Yes.
Now, the Honorable High Court also, in the earlier case, when it come up before the court, he was also directed to file written statement, which he never did. When there is no written statement, then
On what basis issues were framed? When there was no,
on that, whether WS has been filed or not has not been made an issue. In fact, that has not been made an issue. But that is the facts of the case. The High Court has directed the respondent hearing to file written statement, which he never filed. Now, Your Lordship knows that the trial court cannot travel beyond the pleadings.
yes,
And therefore, in any view of the matter, this appeal is to be allowed, Your Lordship. And earlier, the bullet points we have submitted, it may not be exhaustive, but then since it is to be a bullet point, we have submitted a short bullet point, which may not include all the relevant points also.
now you want to make some additional submissions in
So-
addition.
No, Your Lordship.
Because the bullet points which you have provided earlier are with me. I'll go through those.
Your Lordship, yes.
Okay. Yes, Mr. Jamil.
May I place your lordship? Lordship, on the last occasion, elaborate submissions have been made, and also the bullet points have also been submitted. So I think that will be suffice, but then on the submission of my learned friend, which he has made just now, by referring to page 32 of the appeal memo, and that copy lordship will find at page 4, which is clear. Appeal memo, page 34.
Page?
Page 34, which my learned friend has
Oh,
shown
Yes,
to order dated 31/1/86. This was our main case, but the court has failed to take into consideration of this aspect of the matter. Now, agreed by this order of 31-186, the present response for civil revision, Lordship will find at page 36. The order passed in that civil revision. This order is not very clear, but that copy is also not here. But the operative portions are
Now,
legible.
Mr. Jamir, regarding nomenclature of the case,
Yes,
though it is nomenclated as civil revision,
yes.
this ought to have been registered as a title suit.
No, it's in the High Court, Lordship. In the
Oh,
High Court.
Okay, okay, okay. On page 36.
Yes, A7.
Yes.
So here, the operative portion, Lordship will find at page 37.
Yes.
For, I'm reading the last two paragraphs, the operative portion. For the reasons stated above, the imbued order is allowed to stand. In the result, the revision is allowed and the imbued order is hereby set aside. The entire proceedings from the state of examination of the witness are hereby quashed. The case is remanded to the court below with a direction to dispose of the matter after giving proper notices to the parties and also after giving opportunity to the parties of being heard. With the above order and direction, the revision petition is disposed of. The order which my learned friend has referred to at page 34, the type copy, the order dated 31-1-1986. This is the only order out of so many proceedings, about 9 proceedings.
Which
This is
which has gone against you.
Yes, this is the only order court has passed an order in favor of the appellant. That too is an ex parte order, Lordship. Therefore, agreed by this order, I have filed a revision petition before the Honorable High Court, and which is available basics, and the order has been set aside and quashed by this Honorable Court, Lordship. And to conclude, Lordship, the appellant have taken 5 important points in this present appeal.
Yeah.
Because there were exhausted 2 trials, that too by the district judges, one in 2005 and 2019. The 2 decrees have already been passed, but in spite of that, somehow the appellants were successful in managing till date. And now, in the present appeal, what are the grounds of appeal? Those are the important things to be considered by this Honorable Court. What are the grounds taken in the appeal? How they are agreed by the order passed by the learned district judge. So, on that point, they have taken the ground that the photocopy cannot be admitted without producing the original document.
Yeah.
That is one of the grounds they have taken. And then no effort has been made by the trial court to produce original copy and no reasons given. That was the ground taken. Now, on those points, the trial court has discussed all these issues because these points were also raised before the trial. And those were discussed under issue number 3, under paragraph 8 of the imbued order. That is at page 1582 to 160. I'm not referring to all this because on the earlier occasion, Lordship has heard them.
Okay.
Under issue number 3 and in the imbued judgment paragraph 8, page 158 to 160, Lordship will find that. And the appellant got the full opportunity in the 2 trials before the 2 district judge do examine and to cross-examine. And grounds which they have projected in the present appeal has been projected in such a way that as they have not got any opportunity on all those points. But there is no ground and grievance that the trial court has not given us the opportunity to raise all these points. These are not the points in the present appeal, Lordship. Therefore, in the two trials, they have been given the full opportunity to examine and cross-examine, even to the extent of the documents, referring to the documents, and to raise objection as well. What prevented the appellants to insist for original documents during the trial? If it is the ground that they were not given opportunity, and in spite of our objection, the learned court below has not given us the opportunity. If that is the ground, yes, this honorable court can examine in the appellate stage. But then, having afforded full opportunity to raise all these objections, now at this belated stage in the appellate court, they cannot raise those points because they got full opportunity before the two trials.
Okay.
Second ground is that I'm submitting all this on the basis of the grounds which they have taken in the present appeal, because that will be the relevant points to be decided by this honorable court. Now, the second ground is we are in possession. I have made elaborate submissions in the past about the possession. Yes, no doubt, he is in possession. How he is in possession? He has constructed the house in violation of the order passed by this honorable court. And then in defiance of the court, he has constructed the building in the suit land when he was the officer in charge of the Butsoro police station. And Lordship will find that under issue number 7 and 8, at paragraph 12 and 13 of the enjoined judgment, starting page 162 to 164. Lordship will find in those pages how discussion was made, how he has constructed the building in violation of the honorable court's order, all this. Page 162 to 164.
Okay.
Now, the third point, I will raise only 5 points there because they have taken 5 points. So, on all these 5 points, the third point was they have taken a grievance that the learned court below ought to have conducted a spot verification. That was one of the grounds. And in fact, when the suit was pending before the trial court, they have filed an application for a spot verification that was also rejected. During the pendency of the trial before the district judge Peck, they have filed an application for a spot verification, identification that was also rejected because it was a frivolous claim. Lordship will find that in ground number 9, and they have filed an application under section 75, Rate Order 26, Rule 9. That was rejected by the trial court. Lordship will find at page 115, that order. With regard to the possession and for the spot verification. And against that order, they have not filed any appeal. The present appellant, if they are aggrieved by that order passed by the trial court, they could have preferred an appeal. And
This order is at page 115.
Yes, Lordship.
Okay.
115. And now the fourth point, with regard to the float, they are saying that it is a different float and not the suit lane. Those issues they have raised before the Honorable High Court also. Lordship will find at page 52, 5th line from the bottom on this issue. Page 52, 5th line from the bottom. this issue. And also, Lordship will find at page 150 and 115. At page 150, Lordship will find in the cross-examination, below the middle of the page, it is correct to state that I have constructed the building over the suit land. However, I am not so sure about the year when the building was constructed, but it might be up to 1985. I have constructed the building without the direction of any court. So that was the statement of the present appellant in the cross-examination. And the dispute about the dispute is also mentioned. So Lordship may mark about the cross-examination. In the reply, he has already admitted, and when he himself has admitted about the suit land, the question of another flood doesn't arise. The appellant himself is admitting the flaw that yes, I have constructed the building in the suit land. Then whereas the question of identifying for another land, the dispute is only. Therefore, all these irrelevant points are also coming in. Land has no legs, as I was mentioning, they cannot walk. What was there, it will be there. Unless it is ticked out and then taken to somebody else, somewhere else, but means of some technology. And then in page 115 also, Lordship will find.
Okay, your submission is that the appellant himself admitted during his cross-examination that he constructed the building over the suit land.
Yes.
So as he used the phrase suit land,
Yes.
submission is that it refers to the same land.
Correct.
Okay.
Therefore, identify another flaw doesn't arise.
Okay.
So himself we say that I have constructed over the suit land. What left? What is left to be decided, to be ascertained, Lordship? Now, the last point. All the possessions before the ADCJ PEC was quashed and set aside. All the possessions before the ADCJ PEC, that means whatever points they have raised have been set aside and quashed. Now, in this connection, I would like to refer to page 88. This is an order passed by the High Court. It starts from page 77. And I'm referring only to the operative portion. This is the last ground where I want to rely.
Yes.
Page 88, let me read two paragraphs, the second and the third paragraph. May I read, Lordship?
Yes, please.
In this case, as stated above, the appellant in his deposition stated that he had a self-deed agreement and he can produce it as and when necessary. Likewise, in the case of the respondent also, he seems to have depended upon documents which were not even exhibited. In view of what has been stated above, I'm of the view that to do full justice, the parties must be given a chance of proving their respective case properly. I'm aware that this dispute had dragged on for a long time, but it would be better for both the parties and for the ends of justice to have the case tried properly as per law, so that the litigation finally comes to an end. Therefore, the impugned judgment and order is set aside, and the district judge PEC is directed to try the case afresh by giving the parties a chance to exhibit and prove all the documents on which they want to rely on for your respective case. To do that, further examination of the witnesses already examined may be required, and if so, the witnesses already examined may also be allowed to give full further evidence in respect of the documents. All this has been done before the Honorable High Court. When the trial was conducted before the district judge had, no cell date was produced in spite of affording opportunity of being heard. Now, trial court has conducted the trial in terms of the order of this Honorable Court. This is the order. The trial in fact was conducted in terms of this order. There is no grounds in the appeal that they were denied to exhibit the documents. And there is no prayer for remand also. Therefore, taking into consideration of all these factors, my only submission is there is nothing wrong on the order of 17/5/2019, which was passed in civil division, so 2001. And whatever the trial court has decided, it was a reason order, and no ground has been made by the appellants.
Now, regarding this nomenclature of civil revision,
Yes, Your Lordship. In that, allow me to make a legal.
Mr. Jamir, you are done with your submission is over?
Yes.
Okay, yes, Mr. Leader.
Yes,
For clerical mistake of registering the case number in this way, that way, those are not the valid grounds for interfering with the judgment.
No, it will not interfere with the by post title, but now in the impugn order, as we see, it is number 1 of 2001. In the first order, impugn order, which was set aside for the first time, that was also the trial court has used civil revision number 1 of 2001. Similarly, in the present impugn order also, the trial court has used the post title civil revision number 1 of 2001. Now, the revision petition, which has been referred to by my learned friend at page 36 of the appeal memo. From this, he started narrating all his cases again. This is civil revision number 10K of 1986. And below is 1K of 86. If it is in the High Court, in the Kohima bench, within bracket, K is always there. But in the present post title, as reported by the trial court, there is no K. Only civil revision number 1/2001. Civil revision number 1/2001.
What it implies?
Your Lordship,
What it implies?
it implies that by this, Kerati must have filed a civil revision somewhere, which copy we have never received. But instead of looking into the direction of the court, that the petition filed by the present appellant shall be treated as a plain in case number 84 of 1985, that has been omitted. So it should be, post title should be title suit number 84 of 1985. It should be like that. Not civil revision. Because civil revision number 1/2001, for where this has come, we have no copy of this one. I don't know whether my friend has any copy of this one. Because this is not the civil revision filed before the High Court. It's case, any civil revision or civil rule, then if filed in Kohima bench, K will be always there, Kohima, to show that this is a Kohima bench case. So this is a mistake of the trial court. Maybe all the parties are so responsible. Honestly, we are supposed to guide the court, but we have failed. But it should not be civil revision number 1, but it should be title suit or civil suit number 84/1985.
No, assuming this to be a wrong nomenclature,
Yes.
will it impact, will it have in any manner?
It's not impact, because these are not going to the merit of the case. But when I'm to be treated as, my petition is to be treated as a plain, then from there it has to start. They will not affect the merit of the case. So it should be civil suit or title suit number, let us say civil suit number 84/85. 84 of 85 should be 48.
Okay,
Whatever may be the
48
nomenclature,
of 85, I'm sorry. 48 of 85.
put the
So
parties.
I wanted to clarify that one. Let my friend say what he wants to say on that. But they will not affect the merits of the case either way. Secondly, now my learned friend has referred to page 88, which has been passed by the Honorable High Court in First Appeal number 1K of 2006. Now, in this paragraph, which turned out, this is a direction to both the parties to produce documents. Because in the first impugned order also passed by the trial court, no documents was exhibited. And therefore, the Honorable High Court has directed that allowing both the parties to produce documents. Now, despite this direction, what happens before the trial court? Your Lordship may come to page 156. This is paragraph 4 of the impugned judgment. Paragraph 4 of the impugned judgment.
yeah,
I would like to read from accordingly. 5 lines, the 5th line in the
Yeah.
Accordingly, this court issued direction to the party to submit their list of witnesses whom they wish to examine, and also to furnish any documents the parties are interested to file in this regard. However, none of the parties submitted any fresh documents or introduced new witnesses, but instead conducted further examination of previous witnesses. So, no documents have been introduced. If no documents is introduced, then how can the court, the trial court, rely on a so-called exhibit A of the present respondent, and also a notice which has never been produced before the court? And therefore, since the trial court solely relies on these documents which have never been introduced or produced before the court, not to speak of the original, even photocopy has not been introduced in the court and exhibited. However, surprisingly, the trial court relied on a document, a so-called documents, which has never been introduced. Since the only points in favor of the present respondent is based on these documents,
which were never introduced. If that goes according to law of evidence, that cannot be examined by the court, by the trial court. So if that goes, leave aside the other evidence, this impeachment judgment goes. That is my main point. And then I sought inspection of the suit land because in 1975, the present respondent and one Kususa. Yes. The case was settled by the then PA to DC, Kuchong. Now, subsequently, the respondent claims that present suit land on which I have constructed my building as the suit land. But during evidence, it has come to light that the old post office, the suit land in 1975 was lying opposite the old post office on way up to one his name? One
These are all closed chapter.
terrace, one terrace residence, private residence. Now, that is not the location of the present land where I have constructed my building. That was different. So since it has come to light during the course of evidence, we submitted the application for verification. But that was rejected, however. Therefore, there is no question saying that since I constructed on the present suit land, there is no dispute of the side of the subject matter of dispute. The application was filed because of the 1975 land, which has been said to have been compromised between the respondent and one Kutusa. Their land was different. Therefore, in my appeal memo also, I've given a point, a ground that the respondent is trying to interpose that 75 land as the present suit land. But what is important is for the court to proceed on deciding this case is whether the trial court has rightly examined the documents, whether documents have been exhibited in terms of law, and if those documents are excluded from the evidence, then what is the case of the present respondent? Now, my witnesses, Dachone was examined when alive. Now, Your Lordship, one important factor here, even the same mistake was by the earlier trial court.
Whether my learned friend is responding to replying to my submission or just again opening another round of submission.
The mistake, another mistake committed by the trial court is, Your Lordship may see at page 160 of the impugned judgment. Page 160. From the first sentence, in the second line, the veracity from there. Page 160.
Yes.
The veracity testimony of R.W.1 Vetronet is my witness, is doubtful and unreliable for the reason that if he and his brother Dachone have sold the land in 1969, why they have filed application? Now, this witness was not examined by this court. This,
But you had option to examine him. when the case was remanded back.
No, because we have examined him. But what I'm trying to say is that now the veracity of according to the trial court, the veracity of testimony of R1 is doubtful and unreliable. Because now this is demeanor of witnesses. And demeanor of a witness can be calculated only by the court who examined the witness. But this court has not examined this witness. Even in the first case, which was set aside, in that also the same mistake was committed, because this witness deposed before one Kapek Kosa, not Hukato, or not by this court, who is this one, Long Shitong. Neither before Long Shitong Izu, District Judge Pat, or Hukato Su, when he was District Judge Kohima, none of them examined this witness. This witness never appeared before them. But in order to unduly favor the respondent, under what circumstances the court goes to say that his testimony is doubtful?
No, the reason,
There have to be given a reason.
the reason shown by the court was that if you purchased the land in the year 1969, what were you doing since till 84? That
Oh.
was the only reason.
Yes, but then 69, after selling the land to Pire, what business he had with the land? No, he doesn't have. I sold my land, say in 65, to my friend City. Now, after many years, after that, I don't have business, because City has again sold it to another person. What is my business?
Okay.
Therefore, the trial court has committed an illegality in doubting the veracity of this statement when he was not deposed before the present this trial court. And the documents, mainly the documents. When the documents have never been produced, how can the trial court refer to that? As if it is a legally submitted document. So those are some of the main.
One query from Mr. Iralu.
Yes.
The respondent admitted during his cross-examination that he constructed house over the suit land.
Yes.
What is your submission when he's himself admitting that he had constructed his house over the suit land without knowing that it was illegal to do so? Yes, I can hear you.
You know, that the appellant has taken a risk because earlier in the High Court, if he does anything, then it will be at his own risk. That was the direction that was the indication made by the High Court. But since the ownership is clearly vested with the appellant, he proceeded. Because 75 has nothing to do with this one. But on the basis of the 75 case, the so-called compromise between the respondent and Huchosa, he started claiming this. And if your lordship goes to the evidence of the respondent in course of examination, it is clear that the two lands are different. This is not opposite post office. This is opposite the police point. And as we have already given a sketch map by both the parties during your your lordship's last stint here,
Sketch maps are also different, actually.
yes, and my
Both
sketch
have
map
different sketch.
correct. My sketch map is prepared by the party.
That is the claim by Mr. Jamir also.
That was prepared by himself here. So if we are to go by the evidence, even without those sketch maps, now the location is clearly different.
Whatever points my learned friend is raising, these are all decided before this Honorable High Court.
Okay.
So
12 litigations,
everything will now based on evidence.
9 in the High Court.
Whatever I
And
say,
3 in the
whatever my
lower court.
learned friend says, it is
Okay.
not.
Mr. Jamir, one query to you also. How the genuineness of exhibit A would be ascertained when exhibit A, neither the original was produced, nor it was, how the genuineness would be considered by the trial court?
Remain Lordship.
Yeah.
Evidence will take care of that. Evidence Act, Section 165.
Because this is an order of yes,
Remain Lordship.
yes.
I was referring to Evidence Act will take care of that.
Okay.
Section 165, and all this. Evidence Act will take care, and so far as the interpolation of the is interposed of parties referring the case numbers. In short, Lordship, to set aside the decree, Section 99, Lordship may take note of it. Grounds where the decree can be set aside. And what are the restrictions to set aside the decree on a technical ground? Those aspects of the matter may be examined by your Lordship. Otherwise, elaborate submissions have been made by both the parties. Lordship can measure the merits and demerits of in the appeal, and Lordship may decide. It's 48 years of litigation now for an area of 24 by 12, Lordship.
Okay.
I would say that much only, Lordship.
Heard Mr. Musumi. Stenolaki. Okay, I'm dictating. Heard Mr. R. Iralu, learned counsel for the appellant assisted, learned senior counsel for the appellant assisted by Mr. Elivil Zhao. Learned counsel for the appellants. Also heard Mr. C.T. Zamir, learned senior counsel assisted by Mr. N. Longkumar, learned counsel for the respondent. Hearing concluded, judgment reserved.
Much obliged.
Obliged, your lordship.
You may disconnect yourself. No, just-
And the same for item
15 also same, my lord, the interim
15
is
is
there.
same, man.
Item number 15, heard Mr.
P. Chaudhary.
P. Chaudhary, learned counsel for the petitioner, also heard Mr. B. B. Gogoi, learned additional public prosecutor, who submits that though the case, no, sorry, additional public prosecutor, learned counsel for the petitioner has submitted that by order dated 28/7/2023, the petitioner, what is the name of the petitioner?
Rupam Kalita.
Rupam Kalita was allowed to go on interim anticipatory bail by this court. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. So, learned additional public prosecutor has produced the case diary of Palashwari PS case number 228/23 and has submitted that the petitioner Rupam Kalita has appeared before the investigating officer and his statement under section 161 has also been recorded. Stop considering the above facts, as well as considering the fact that the petitioner has complied with the directions of this court, the order dated 28/7/2023, whereby the petitioner was granted interim anticipatory bail, is hereby made absolute.
Deeply.
Let the case be accepted.
Deeply.
Item 17,
May it please your lords. This matter, your lordship, 439, 38 application, your lordship, in the interim, the petitioner has already been granted anticipatory interim bail. The petitioner has already appeared before the authorities concerned, IO, on 410. And your lordship, in fact, the matter relates to, with regard to the FIR, which is at page A. In the FIR, your lordship, there is no name of the petitioner.
Case diary is there.
Case diary received, my lord, he is in interim, his statement is not there, but I will notice that he appeared.
Appeared and recorded on 4th of 410.
Heard Mr. Y. S. Mannan, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 21/9/2023, the petitioner Mohammed Naziuddin Ahmed was allowed to go on interim anticipatory bail by this court. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, an additional public prosecutor has produced the case diary of Morigaon PS case number 282/23, which was called for the connection of this case, and has submitted that the petitioner has appeared before the investigating officer in pursuant to the directions of this. Considering the fact that it appears that the petitioner has cooperated in the investigation and has complied with the directions of this court, the interim anticipatory bail granted to him by order dated 21/9/2023 is hereby made absolute, subject to the condition that he shall continue to cooperate with the investigating officer in fair completion of the investigation. Send back the case study. This case is accordingly disposed.
Much of it.
18,
Here also, my lord, CD was called for CD received. He is in interim, my lord. He appeared before IO. This case of my lord, 2016.
Mr.
S.I. Talukdar.
S.I. Talakdar, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 21/9/23, the petitioner Ashraful Islam was granted interim anticipatory bail by this court. And in pursuant to the directions of this court, petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor, while producing the case diary of Fakirganj, PS case number 258/16, which was called for in connection with this case, has submitted that the petitioner has appeared before the investigating officer and his statement
Recorded.
has also been recorded under section 161 of the CRPC. Stop. Considering the fact that after getting interim bail, the petitioner has been cooperating in the investigation, the interim order dated interim anticipatory bail granted to the above named petitioner by order dated 21/9/23 is hereby made absolute. Send back the case.
Item 19,
That's all. Thank you. In the 438 application, madam, case diary was called for, madam.
Malad, here we have
Here, in the instant case, madam, 4 and 5 were
interim.
protected, madam.
There appeared, Malad, statement recorded.
4 and 5 protected, madam, and so far one is concerned, madam, he is arrested.
Arrested. Malad, here we have received the case diary along with the medical report, Malad.
What is the injury?
Injury report previous by sharp edge weapon, Malad.
Who-
Previous by sharp edge weapon, Malad. Sharp weapon.
Okay. Who caused?
Malad, that is caused by the Malad Lalsan Paramanik. Malad, from the statement of the witnesses, Malad. And it was Dao, Malad. It was taken by the Anna Khatun, Malad. Hiding the Dao, Malad.
No. Who assaulted?
Assaulted by the Lalsan Paramanik, petitioner number 2, Malad.
And
And the
Anna Khatun did?
instrument, Malad, Dao, Malad. Hiding the Malad in his hari, Malad. Anna
She took it to the place.
Khatun, Malad, place to the place, Malad. Witness, from the statement of the witnesses, Malad.
As regards Lalchan Khatun,
Lalsan Paramanik, Malad.
Lalchan Paramanik,
Wow. Malad, he has inflicted, Malad, that is dear, Malad. From the statement of witness, Malad.
his custodial
Malad.
interrogation. As regards Anna Khatun,
Anna Khatun, Malad, she has hide the Malad instrument, Malad, weapon, Malad.
weapon has been recovered.
Weapon, Malad. Is there 9? Malad. And she has hide the weapons, Malad. In her hari, Malad.
As regards other petitioners,
Others, Malad, they have appeared, Malad, statement recorded, Malad, no such implication, Malad. 3 and 4, Malad. No. 4 and 5.
Mr. N.J. Datta, learned counsel for the petitioners, also heard Mr. B. Sharma, learned additional public prosecutor. This application under section Criminal Procedure, 1973 has been filed by 5 petitioners, namely Habibur Parmanik, Lalchand Parmanik, Anna Khatun, Kalu Parmanik, and Fulchand Parmanik, who were apprehending their arrest in connection with Sapor PS case number 181/23. Stop. During the pendency of this anticipatory bail petition, the petitioner number 1, Habibur Parmanik, was already arrested. And therefore, the instant application with regard to the said petitioner has become infructuous. As regards petitioner number 4 and 5, namely Kalu Paramanik and Fulchand Paramanik, it appears that both of them were allowed to go on interim anticipatory bail by order dated 25/9.
Yes,
25/9/2023, and it is submitted by learned counsel for the petitioners that both of them have appeared before the investigating officer and have cooperated in the investigation. So, as regards other two, what is the submission? Mr. Dotto?
My lord, so far three is concerned, my lord. My lord, she is a lady, my lord. And two, my lord, I leave it to a lot of my lord, because
my lord.
Learned-
Dialysis levels, my lord, is improving.
three, your
Complication.
lordship, three, your lordship, I consider being a lady, my lord. And she has not inflicted the injury.
Learned counsel for the petitioner has submitted that the petitioner number 3, Anna Khatun, being a woman, may be considered for grant of anticipatory bail as she has herself not inflicted any injury on the informant,
Victim,
on the victim. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Sapor PS case number 181/2023 and has submitted that the petitioner number 4 and 5, namely Kalu Paramanik and Fulchand Paramanik, have appeared before the investigating officer and their statements were also recorded. As regards other two petitioners, namely Lalchand Paramanik and Anna Khatun, an additional public prosecutor submits that there are sufficient incriminating material against both of them, and the injury report of the victim Kancha Paramanik shows that he suffered multiple stab injuries in which he sustained grievous injuries, and the nature of weapon used for causing such injuries was found to be sharp-edged weapon. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary as well as the injury report annexed therein. Stop. As the petitioner Kalu Paramanik and Fulchand Paramanik have cooperated in the investigation after getting interim anticipatory bail, the interim anticipatory bail granted to them by order dated 25/9/2023 is hereby made absolute with following conditions. Number 1, they shall continue to cooperate with the investigating officer of the case and shall appear before him as and when so required by the investigating officer for the sake of fair investigation. Number 2, they shall not make any inducement, threat, or promise to the victim or any person who is acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the investigating officer. Stop. As regards petitioner Anna Khatun is concerned, though there are incriminating material against the said petitioner, however, it appears that she has herself not inflicted the injuries on the victim, coupled with the fact the said petitioner is a woman, this court is of considered opinion that her custodial interrogation may not be necessary if she otherwise cooperates with the investigating officer. Hence, the petitioner Anna Khatun is hereby directed to appear before the investigating officer of Sapor PS case number 181/2023 within 10 days from date of this order and cooperate in the investigation. And if she does so within the stipulated period of time, in the event of her arrest in connection with Sapor PS case number 181/23, she shall be allowed to go on bail of ₹30,000 on surety of like amount, subject to the satisfaction of arresting authority with the conditions which were already imposed with regard to petitioner number 4 and petitioner number 5 herein above. Stop. As regards petitioner number 2, Lalchand Paramanik, as there are sufficient incriminating material against the said petitioner and as the injury sustained by the victim is grievous in nature and considering the weapon of offense used for inflicting such injuries, this court is not inclined to grant the benefit of an order under section 438 of PRPC to the said petitioner at this stage of investigation. Hence, his prayer for grant of anticipatory bail is hereby. This anticipatory bail application is accordingly disposed of, send back the case.
I'm deeply obliged.
Item 21,
Yeah, my lord, here is CD not received, my lord. They are interim, you know.
My lord, as per this honorable court's order on 10/10, I already appeared, my statement is already recorded.
Let us wait for.
My lord.
Once.
Hmm.
Heard Mr. J. Abedin, learned counsel for the petitioner, also heard Mr. P. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived, and prays for some more time for producing the case diary. Prayer is allowed. Let this case be fixed again on
4th of December. My lord.
4th of
My
December.
lord, could it be a bit later? There was a lag on my part because I had to send the notice was issued to respondent number
Oh,
2.
Yeah.
And my lord, because of some inadvertent mistake, it was not sent by my clerk. So I'll take the steps tomorrow.
This
This is the informant I made the party in this bail application.
The offense is under,
366.
you have to send it, otherwise it will affect your interim bail.
Yes, no. Definitely.
Let this case be fixed again on
My lord. 4th, my lord, 4th.
4th of December. The interim order shall continue till next day.
item
You
20,
have to, I'm not mentioning it in the order sheet, but you have to take steps.
I'll take the steps tomorrow.
Otherwise, interim order will be vacated.
Deeply obliged.
22,
May please the lordship. My lord, this is 4th date, my lord. For waiting for CD, my lord. And the FIR, lordship, my lord. He has not received case diary, my lord.
The offense is under section.
My lord, on section 376, my lord, even if the allegation is assumed to be correct, my lord, it cannot be a 376. It's a consenting action, clear, my lord. The statement of the allegation is a consenting action. Even if the allegation is true, but the petitioner denied the allegation.
My lord, short date may be given, my lord. We will put it back in there.
So, my lord, he may be given a interim protection, my lord, court date, my lord.
No, in the meanwhile, whether police have,
Not arrested, I think.
you are saving yourself.
My lord. Yes, my lord.
Wait for few more.
My lord.
No, is there any statement that police is,
My lord, police is searching, but not
Not
arrested.
mentioned, no.
perusal of the case
Searching
diary?
paragraph 3, my lord.
No, perusal of the case diary would be necessary.
My lord.
Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor,
My lord.
who submits that though the case diary was called for, however, same has not arrived. And prays for another date for producing the case diary. The prayer is allowed. Let this case be fixed again on
My lord. 30, my lord.
30/11. The 30/11 for case diary.
My lord.
Item
Keep.
23,
Made your lordship. This matter, earlier lordship dealt my lord that suspected to be my lord that gold metal in the railway station. And the police constable, they have allowed the person to go. One person is arrested. And these persons by 438. And your lordship's order is there, my dear, your lordship, there about the 439. Everything is detailed mentioned, my lord. Now, if your lordship kindly say first FIR, my lord, then
Same affair.
same FIR, same FIR. That was 439. And we are the, along with that person, my lord, we are the constable, or home guard, sorry, home guard. All are home guard. FIR page 11. Page 11.
This person was suspended.
That was suspended and he was arrested. Initially, it was 389, which was bailable. We came before the Samuel court. Thereafter, my lord, once he goes there, 387 added. 387 is non-bailable, my lord. So I am, because of 87, I am apprehending arrest. We are also apprehending arrest. Earlier is registered as 389 and on 12, it was subsequently added only to make it non-bailable.
Okay.
Now, from the FIR, you sold the money also returned back as per FIR also. Your lordship also mentioned, my lord.
CD is there.
CD is received, my lord. CD received, my lord. Here is the, my lord, allegation is that there are the, my lord, home guard and police personnel, my lord, in the railway duty, my lord. When the two persons came there, my lord, they have taken and found one, my lord, one now, my lord, golden now, my lord. Boat,
Boat.
golden boat, my lord. Hereafter, they have threatened that if they will give some money, they will release him on that spot, my lord.
But the
Thereafter-
main accused has been released
Yes.
on bail.
My lord, thereafter, my lord, all of them accused person, all of them, my lord, they are
No, they were together, led by
all
that
of them
person.
together, all of them
Led
together.
by their home guard, were temporary home guard. Now they have been discharged also, my lord. So they are temporary.
Let them appear.
Yes, madam. Will appear, madam. Will cooperate.
Let them appear.
And money also taken back, madam. Your lordship.
Money
last-
taken back. my
Yes,
lord.
madam. Money was returned also.
Heard Mr. H.R.A. Chaudhary,
Mm.
senior counsel for the appellant,
1 lakh টাকা ফেরত দিছে বোধহয়।
assisted by Miss
Yes, yes.
S.S. Zia, learned counsel for the petitioner.
মোবাইল দিতে পারে।
This application under section 438 of the Code of Criminal Procedure has been filed by the petitioners, namely Montaj Ali, Rizul Ali, Tohidur Rahman, Tobedul Haq, alias Tobedur Haq, who are apprehending their arrests in connection with GRPS case number 187/2023 under section 120B/389/3
Added. Added, please go.
My lord,
87
387
of the Indian Penal Code. The accusation in this case, quote from this, Amita. Quote. I'm marking. I have put paragraph, quote there. Learned senior counsel for the petitioners submit that the main accused in this case, namely
Moran Chandra
Moran
Das.
Chandra Das, who was earlier arrested in connection with this case, has already been granted bail by this court. It is also submitted by learned senior counsel for the petitioners that in the meanwhile, the money which was alleged to be have been illegally obtained by the present petition
petitioners, my lord, 1 lakh rupees
Yes.
they have taken, my lord.
have
Page 11, my lord.
have been returned back.
You can be here.
Learned senior counsel for the petitioner has also submitted that the petitioners who were earlier home guard have already been discharged from their
They are only temporary in nature, my lord. These home guards are temporary in nature.
discharge and they are ready to cooperate with the investigating officer. On the other hand, the additional public prosecutor has produced the case diary of GRPS case number 187/23 and has submitted that there are sufficient incriminating material against the
They have also
present
admitted, also other,
present petition. Otherwise, what is the progress in the case?
my lord. Investigation is going on, my lord. Investigation is going on.
Statements have been recorded.
My lord, statement they have not appeared, my lord. They are not.
No, not there.
Other.
Others, my lord, statement are there, my lord. Witnesses are examined, my lord.
An additional public prosecutor has submitted that in the meanwhile, the statement of main accused, namely Moran Chandra Das, has been recorded and some of the other
Witnesses
witnesses'
also.
statement have also been recorded. Stop. I have considered the submissions made by learned counsel for both the sides and also perused the case diary which is available before this court. Considering the fact that main accused of this case, Mr. Moran Chandra Das, who was earlier arrested, has already been granted bail in this case. Also considering the fact that the investigation has fairly progressed, I am of the considered opinion that custodial detention of the above named petitioners may not be necessary if they cooperate in the investigation. Stop. Hence, the above named petitioners are hereby directed to appear before the investigating officer of GRPS case number 187/23 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with GRPS case number 187/2023, the above named petitioners shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority, with a condition that the above named petitioner shall cooperate in the investigation. Any other condition?
And appear before the IO as an
And
unrelated.
shall appear before the investigating officer as and when
Only.
so required by the investigating officer
Right.
for the sake of fair investigation. With above observation, this anticipatory bail application is thereby disposed of. Send back the case.
Item 24,
May I please, Your Lordship? 430 application, Your Lordship, page 9 is the FIR, Your Lordship. It is request number 4 and 5, Your Lordship.
My lord, here we have received the case diary, my lord. We have received the case diary, my lord. But here we have also received the PM report. But the cause of death was not ascertained in the PM report, my lord. It was sent for FSL, my lord.
What was the allegation in the affair?
The FIR allegation is that the petitioner, 6 accused person is there. They assaulted,
Assaulted.
as per allegation,
Okay.
as per allegation.
The assault is no, injuries were not found.
Found, my lord. In the PM report, injuries were found. Thereafter, it was sent for FSL, my lord.
And after that, he jumped, after instead, he jumped in the river. Accused number 2
So
says-
whether the death is by drowning or by
Not ascertained.
what FSL will suggest?
My lord, here, cause, my lord, opinion, my lord, opinion to the cause of death is kept pending till the receipt of report. All injuries described were antemortem and caused by blunt force impact,
Okay, injuries were there.
my lord.
No, is there any material against the present?
Material is there, my lord, material is there, my lord. Material is there, my lord,
Flag
my lord.
Abhishek and
petitioner number. No, Mr. Sharma,
My lord,
whether materials are against Mr. Paulu Sheikh and Amir Ali.
my lord,
Specific allegations
my
are
lord,
there.
160. 160. Hereafter, my lord, two victims are there, my lord. One is in an injured condition, my lord. His injury report also not received. One is died, my lord. And other is, my lord, injury report is not received, my lord.
inspection, they have also delivered there, accused number 2 says the victim. He jumped in the river, he died. As per my instruction. But there is no assault by the victim. They were playing carom boat in their vehicle.
Witnesses are there, my lord.
Who died? Shahid.
Sabit Hussain Chaudhary.
Sabir Hussain Chaudhary died.
Sabit Hussain Chaudhary. That's why he jumped in Goriazan river. And died. They appeared that they killed and thrown about 325 in there.
What are the names of the petitioner? Palu and
Falu and Amir Ali.
I'm here, my lord.
Amir Ali. Ali Sheikh.
now what is the submission?
My submission is it is the, my lord, earlier stage, my lord. Lordship may call for the FSL along with the injury report. One is injured person is, his injury report is also, along with the CCTV footage also there, my lord.
As per Mr. Secretary, they are there. We will be-
Also
and
police
cooperative.
CCTV footage, my lord. That report also call for, my lord.
As per Mr. Secretary says that Baten Sheikh
Then
is-
in the meanwhile, let them appear.
No, my lord, I have the objection at this stage, my lord.
There is no
I have the
allegation
objection,
against
my
them.
lord, 302, otherwise, my lord, I have no
Very
objection.
clear that is-
But
but
it
there
is the
is no-
matter of 302.
Postmortem report is silent. There is no indication against the petitioner. So it's
No, but
cooperative.
there are material against.
There is also
Material, my lord,
indicated-
164 statement is there, other injured
Okay,
person
let
statement is
us-
also there.
Let us peruse the other material.
My lord.
We will protect it, we will cooperate, your lordship, but the CC footage is there, external inspection also there. The CC footage also there.
One is
But
injured
petitioner
person,
is
his
not there.
statement is also there, my lord. How they were assaulted, my lord, thereafter,
CCTV footage is there or mobile video. video
CCTV footage, my lord, CCTV, when it was going through all the accused person, my lord, he was throwing, my lord.
No, external inspection.
Thereafter-
After the incident, they have had the incident, that there is the incident is there, after the accused number 2 and the 15, then they have run away.
All of them running after the, my lord, disease, my lord.
But they did not assault.
Where is the affair?
FIR, your lordship, page 9, page 10 years the reading. Page 10. FIR, some exactly that they have assaulted.
Okay,
Right and
no,
thrown the
this is a case of 30. Let us wait for FSL.
My lord, my lord,
We'll give a shot.
my lord.
Mr.
Yes.
S. Islam, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor, who has produced the case diary of the
Not blocking.
North Lakhimpur PS case number 363/23. However, he has submitted that though the case diary contains the postmortem examination report, however,
Cause
the
of death.
cause of death could not be ascertained during the postmortem examination. And further examination and the forensic laboratory report in this connection awaited. So learned counsel for the petitioner submits that
Therefore, I have stated.
that the result of the FSL report as well as CCTV footage.
An injury report of the victim and the victim.
The FSL is there.
Right.
The postmortem exam,
Right.
other victims are there,
Mm,
and the injury reports of other victims may be necessary for instant data. Hence, call for the FSL report as well as a report from the IO. He should not send us the CCTV footage.
My lord,
He should go through the CCTV footage
my lord, report, then they will
and
send back a report.
what was the statement? Call for a report from the investigating officer after perusal of the CCTV footage as regarding the implication of the present petition in this case. After receipt of the aforementioned FSL report, injury report of the other victims and report as regards the CCTV footage, the prayer for bail of the present petition. Fixing
My lord. 1st of December, my lord.
case diary would be sent back and
Well.
fixing 1st of December for the reports. Let the case diary be sent back to be called again on the next day.
Particularly, if there is something material, it may be rejected here, but nothing is there. We will cooperate here, but if something material is there, after taking there, we are not rejected it.
No, let us wait.
It will take time.
If it does not come, you may again press for on that. We will consider your appeal.
My lord.
Item
Obvious.
21 of supplementary date.
Maybe lordship, 413(8) application lordship, the FIR phase 10 lordship. The petitioner name is not there lordship, 3 accused lordship, I am the owner of the vehicle lordship.
Then why are you apprehending your arrest?
Lordship, the case lordship, 22 lordship, the Zimba order lordship. I am apprehending
Case
to
diary
the.
has been received.
Yes, they receive, my lord.
Is
Yes, they
there,
receive, my lord. What happened, my lord? Some accused person coming from the, my lord, Nagaon side, my lord. Thereafter, police apprehended. That part is FIR from, my lord. Thereafter, investigation, it was found that the vehicle used by the accused person, who is involved in the, my lord,
Brother lordship, joint family lordship.
who was
my-
involved in, my lord,
ATM fraud?
my lord, ATM fraud, my lord, ATM fraud. Thereafter, apprehended several ATM cards were
Okay,
recovered.
but whether the
Present petitioner, my lord.
present petitioner,
The vehicle used by the accused person is that is
Brother
the
lordship.
owner of the
Brother.
owner of the present petitioner,
So my brother
otherwise,
was
apart
arrested.
from the owner of the vehicle, being owner of the vehicle,
my lord.
there is no allegation.
Not at present, my lord.
Let him appear.
My lord.
Heard Mr.
Ken Ahmed.
N. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973 has been filed by the petitioner Hifzur Rahman, who is apprehending his arrest in connection with Jagirot PS case number
Zimma order.
238/2022 under section 238/307/427/468/471/34 of the Indian Penal Code. The gist of accusation in this case is that on 10/8/2023, one Viman Kaur, ASI of Nelly Police Outpost lodged an FIR before the officer in charge of Jagirot Police Station, inter alia, alleging that on receipt of an information through secret sources that 3 persons involved in ATM fraud were coming to Nagaon side, were coming from Nagaon side to Guwahati in a blue color Swift car bearing registration number AS01 EG6815, and accordingly a Naka checking duty was conducted. Stop. Later on, when the said car approached the Naka checking area, it was signaled to stop. However, the driver disobeyed the signal and barged against the barricade, and in the process injured the police personnel working, injured some of the police personnel on duty. Later on, the inmates, later on, the vehicle was intercepted and the occupants of the said vehicles were arrested. They were found to be involved in ATM
37 numbers of ATM card
fraud and
and card
37 numbers of ATM cards, 1 swipe machine, 4 numbers of mobile phone, and some other materials were seized from
from the
their
vehicle.
possession. Stop. What happened to the other accused, those 3 accused, whether they are on bail, Mr.
Other accused,
Other accused person?
Other is only release on bill.
they are under, they are arrested.
Arrested. 3 arrested lordship, release on bill.
Learned counsel for the petitioner had submitted that the petitioner is no way involved in the offense alleged in the affair. His only involvement is that one of the occupant of the vehicle is his own brother,
Hanifur Rahman.
My lord, from
namely
his position, several acting
Hanifur Rahman.
Hanifur Rahman.
who was involved in.
And the vehicle which was seized in connection with this case is his own vehicle.
No.
Stop. Learned counsel for the petitioner has submitted that as the petitioner as accused Hanifur Rahman is the brother of the present petitioner, he allowed the petitioner to use his vehicle without knowing anything about the
Yes.
misdeeds in which his brother was indulging in. Stop. Learned counsel for the petitioner has also submitted that the petitioner would cooperate in investigation if he is allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that has produced the case diary of Jaggi Road PS case number 238/2022 and has submitted that 2023 and has submitted that the earlier PS case is 23, make it 20. In your petition, it is 22. And has submitted that
20.
that though there are incriminating material against the other accused persons, it appears from the case diary that the present petitioner is the owner of the vehicle which was seized in connection with this case. And he allowed his brother, who is the main accused in this case, to use the said vehicle.
Such type of offenses.
Stop. On the said ground, done it. Additional public prosecutor has opposed the grant of anticipatory bail.
At this stage,
petition.
investigation is going on.
Stop. I have considered the submissions made by learned counsel for both the sides and have perused the case diary of Jaggi Road PS case number 238/2020. It appears from record that there is no specific allegation of present petitioner himself being involved in the alleged ATM fraud scam. However, it appears that the vehicle which was used by the main accused persons belongs to the present petition. Stop. Considering the fact that at this stage of the investigation, there is no material on record to show that the petitioner was himself involved in the ATM fraud scam, the present petitioner, namely Hifzur Rahman, is directed to appear before the investigating officer of Jaggi Road PS case number 238/23 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Jaggi Road PS case number 238/2023, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of arresting authority, with a condition that he shall cooperate with the investigating officer in fair completion of case and he shall appear before the investigating officer as and when so required by the investigating officer for the sake of fair completion of case. With above observation, this anticipated bail application is hereby sent back.
Deep blue.
Item 32 for orders.
May appeal, Lordship. In this case, my lord, petitioner appellant is convicted.
It is a bail pending appeal, my.
Aye.
376 my 10 years sentence. And I only take by your lordship kindly see just my lord 164 statement your lordship.
Have you
Page
filed-
24.
Yes, we
will
have
be-
file objection, madam.
This already filed.
Okay.
Already you are about 6 months, my lord. Now on the face of it, my age has not been determined, my lord. After the occurrence, she has my lord produced one pen card. That 4 years, that court has not accepted. But medical says, my lord, above 16 years, below 18 years. Medical says, my
Victim.
victim.
Okay.
And medical did not find any sign also, my lord. Just my lord, medical, your lordship kindly see, medical page
How much punishment was
10 years, my lord.
10 years?
10 years.
First, it was registered under section 4 of POXO.
POXO, my
But,
lord,
uh,
but since
yes.
alternative under section 42 of
Yes.
the POXO, my lord, alternative that punishment has been given. Greater punishment was given.
Punished under section
376 1.
376(1).
One. All the conviction under both sections, 1 and 4 also.
Whether the notice have been served on respondent number 2.
Yes, they have already filed.
No, no.
Steps taken, but.
They have
I
taken on
check up that
36/23.
Service report, I think not. Written.
Oh,
But notice on respondent number 2.
Yes, they have taken step.
Yes, steps taken, my
No, but taking steps will not.
36/23. 36, my. Office. note
There is
taken.
no office note regarding taking of
No,
steps,
no, step.
because you have to take steps and then she has to be.
That's too much. POXO case, my lord, that is.
No, now, no.
Now question number 376 1. That is not, I think, my above 10 years, my lord, is to be given. 389 your was given. The service is. Above 10 years, my lord, notice is to. Not below 10 years. 389. my lord. Pending an appeal by convicted person, the appellate court may for reasons to be recorded by its in writing order that the execution of the sentence of the order of appeal again, if he is confined that he is so and so, provided that the appellate court shall before releasing on bail or on his own bond the convicted person who is convicted of offence, death or imprisonment for life or imprisonment for a term of not less than 10 years, of not less than 10 years, shall give opportunity to the public prosecutor for showing cause in writing against such release. That is given, public prosecutor, they already filed objection. So private party, that is not there.
No, but you have made the
Party.
I have made them party, my lord, but that is because this law says, my lord, that is enough. I may also, my lord, play for striking down of that here, my lord. But that, of course, normally, my lord, party, they are normally the victim or the informer is implicated in the people. But my appeal under 389 for suspension of sentence.
now why sentence should be suspended?
Huh?
Why it should be suspended?
Sentence. Sentence, my lord, 164, she has in the 376. But just click to my lord, 164, my lord,
Yes,
page 24,
page 20.
page 24.
This is a appeal of 23.
Yes. 23, it was filed, my lord. Judgment is dated 31st May 23. And page 24, I read in class 5, 6, 7, 8, my lord, but she did not post any certificate about the 8. Picnic in the house. My younger sister went out for a latrine. I was standing on the road. Akkas came. He took me to his house on foot. It was 8 to 8:30 o'clock the night. He took me to nearby I River, taken to the middle of the Kohura Bank. There we have so and so, so and so. I love accused. Akkas did not apply any force at the time of so and so. I also wanted. I was concealed 3 days in Akkas' house. After 3 days, the family members Akkas saw me and assaulted. The family members Akkas threatened me to kill so and so.
3 days.
Yes. And occurrence 1116. Now, medical report, just have a look to page 17, my lord. Page 17. Page 17. 17 start, page 18, your lordship there, main my lord. Your lord, page 17, history, your lordship. She gives history of lab, FIR with accused for 4 months. Your lord, kindly note, medical, she is saying she is in lab. Then absconded on so and stayed with him for, she absconded and stayed with him for 3 days and they had so and so. Then you also at page 18. Opinion. From the history, chemical examination and investigation, it could not be certain if she was raped or not. Now, 313, your loss kind, this is 313, my statement. That is also mine. I have taken the plea also page 52 also.
No, regarding age, what is your submission?
Or age, my submission, because if it is below 18 years, Joymala case comes, other case comes, plus 1 year, 2 years, plus minus. Supreme Court is so many cases are there. I am also having some cases. 1 or 2 years, either way, that can add it. Since down, if there is certificate, then section 34 of the Juvenile Act will come. But Juvenile Act says, if there is birth certificate, that will get precedent. If it is done, school certificate. If none of that is available, then question of medical test will come. She is saying that she was reading in class 8. She did not produce anything. After 4 years, she is producing one pen card. After 4 years. And this judgment also,
In the pen card, what was the age?
Age 1, it is here, my lord. It was written your lordship point. Page 2:1. Below 18 years, it comes, my below 18. Pen card was page photo.
But pen card is not.
My lord?
Pen card is it? Can it be?
Pen card, your lordship fine. Page 28, your lordship.
No.
Huh? Oh, appeal. Page 28, your lordship. Oh, page 28. Oh, appeal. In appeal memo, your lordship, page 28. Appeal memo.
No, it was page 28. Bill application, page 28.
Yes.
Pen card.
Page 28 of the appeal, my lord. Now let us scrutiny whether the victim was a child within the meaning of section 2D of your lord. Page 28 of appeal memo. Judgment is given, man.
Yeah.
From the judgment, paragraph 26. Your lordship got it, man.
Yeah.
Now, as regards the age of the victim, PW1, that is victim herself stated that at the time of occurrence, she was studying in class 8 and was 16 years old. PW3, Anna Khatun, the complainant and the elder sister of the victim stated that at the time of occurrence, victim was 16 years old. She exhibited the pen card of the victim as material exhibit P1, which was seized by the police. Pen card was seized by the police. Medical officer anima examined as PW4 stated that on the basis of the physical, including so and so, she was of the opinion the age of the victim is above 16 years and below 18 years. Then again, another Dr. Hafiza Ahmad, another medical officer examined PW5, also stated that at the time of examination, a victim was above 16 years, below 18 years. From the evidence as discussed above, it is found that the age of the victim was above 16 years and below 18 years. And as such, she was filed with the meaning of one. It is purely a technical meaning, my lord. So my question, madam, she was 18 years, our critical statement, she did not produce, so naturally it will come out that time, madam. And 1 year plus minus, it is there, madam, already was in judgment. Very good point.
Yes, Mr.
Yes, Lordship,
Sumi. So otherwise, your submission is that the victim was a consenting party.
Exactly.
Merely
She
because
is
of
not minor, she was not minor.
merely, no, whether the court was correct in holding her to be a minor. Trial court
No,
held her to be a minor.
no, not correct, minor. Because cannot say.
That you will show in the appeal.
Even she court say below 60, above 16 years, below 18 years. Supreme Court says, minor. I'm giving the judgment,
that
minor.
variation,
Yes. Your lordship, first is page minus 2022 6 SCC. Asani. Okay. Over there.
What is this?
Yes. Yes. Medical board, my dear lordship, is between that is 23 years. Hence it cannot be ossification test. Hence it cannot be reasonably expected to formulate a uniform paragraph 18 I am reading. Standard for determining the age of the union of episodes on account of the variations in clinical. 18.
case hold it here,
Joyamala Thakur.
164. Variation from years for 76.
Why the appellant was not punished under POXO Act?
Punishment. Because section 42 man, of POXO Act, your lordship. Alternate punishment. Court has discussed, my lord. In the judgment, it is discussed.
For not punishing
Uh,
under POXO Act.
Yes, now, fair said, greater punishment is, whichever greater punishment, that will be punishment will be. Court has discussed, my lord.
That under section 42 of.
42 of the
provision is there, my.
It is there, they have discussed it. Yes, page 84 of the IMI. In view of section 42, I sentence the accused for the offense of section 376. And it starts from page 83. Page 83 of the IA, paragraph 41. Page 83, paragraph 41 of IA.
Yeah.
As discussed above, it is proved beyond all reasonable doubt that the victim was below 18 years of age at the time of occurrence. And on the day of occurrence, accused committed so and so offense under section and also committed offense of section 4 of the POXO Act. Accordingly, accused is found guilty and convicted under section 376 and 4 POXO. Considering the nature of the offense, accused does not deserve so and so. Section 42 of the Act read as follows. Your lordship will find. Where an act of omission constitutes an offense punishable under this Act and also under section so and so, section of the Indian Penal Code or section so and so information to the Act, then notwithstanding anything contained in any law for the time being in force, the offender found guilty of such offense shall be liable to be punishment under this act or under the Indian Penal Code as provided for punishment which is greater in degree. In view of the section 42, I intend to sentence the accused for the offense under section 376, one of the IP. So conviction under both and sentence was given at 376 in view of section 42 of that. But in fact, both the sections deal with the same sentence.
So if the offense is under POXO also,
POXO, my lord, because conviction under POXO, sentence.
so materials were.
I am
found
now,
under-
I am not asking, not conviction, I am asking for the suspension of sentence. I am not praying before worship, but this is for suspension of sentence, not suspension of conviction.
No, but you must have a good probability of,
About 8.
no. Your appeal, there should be a good prospect of your,
Prospect of acquittal, my lord, already it appears to be consenting party, even if it is found, even found to be correct.
no, suppose they are consenting party.
Yeah.
But POXO comes.
No, POXO comes, but if it is proved that can it be, my lord, only because of this saying by the court below, that will do, or they will have to take the materials on the record, other materials are to be taken, my lord.
So your submission is that materials are not sufficient.
Not sufficient to say that she is a child at the relevant time. This is my case, my lord. All cases on that, my lord. And it is a bail purpose, my lord. I think my ultimate conviction is that your court will see, my lord.
No, but once you are convicted,
No, but bail,
no, the
sometimes
bail under-
prima facie, if your lordship fine. At least I think my prima facie is satisfied.
what should be the consideration for the court while considering a bail under?
About age, your lordship is to see only because if she comes over, that if I can satisfy
No,
your
no,
lordship.
my query is what the court should consider while considering an application under section 389.
389. Basically, a chance of success, man.
Chance of. So do you have that?
Yes, man. I think in my humble mind, because that here, man. If it is found that she herself said, I love him. I also wanted to have relation with him, man. Your lordship has seen this thing, man. That is on record. Then how it will be a forceful one, man?
Okay,
This is my case, man.
let me go through the record.
My lord, it's certainly your.
Heard Mr. H.R. assisted by Mr.
AMR.
A.M.
Yeah, Muhammad.
Also heard Mr. B.B.
Gogoi.
Let this case be listed again on day after tomorrow. Let this case be listed again on 16/11 for order, delivery of order.
But if there is judgment, some other judgment, something, I will submit to that court.
Yeah.
By tomorrow. It will be there.
You mean
About 8%.
you were referring to Joymala?
Joymala and other things also, other judgment I have got, my lord. Unfortunately, they have not gone through it, my lord. I have also not.
You may submit tomorrow.
Tomorrow. Yes, that is what I'm
This
saying.
case is fixed day after tomorrow.
Day after. I'll submit to the court master. So that copy you may take back, my lord.
Yes. Need to return for it.
We shall give, my lord, all the real submit that.
Chamber.
All right.
IA criminal lordship.
Yes.
Lordship, in this case, on last Friday, I moved a criminal petition, lordship, where I have prayed for quashing the 133 proceeding. And after perusing entire materials, your lordship was pleased and satisfied. Then lordship stayed the last order of the 133 proceeding. And after that, lordship, we could not obtain the certified copy on Friday, your lordship. Thereafter, lordship, we have information that the police came to the plot of land with another copy of order, that is 811 order, lordship. That I have annexed along with this IA, your lordship,
At
as
page?
annexure D, page 18, lordship. It itself reflects that we have filed an adjournment application on 811 First paragraph, Lordship.
Yeah.
May I read? CR put up on date, first party present along with learned advocate and submitted Hadira and also submitted a separate petition praying to remove the obstruction over the schedule mentioned path. Second party number one submitted a petition stating that due to non-availability of necessary documents, they are not able to submit the show cause reply and hence prayed to allow another date to submit their reply. On that day, Lordship, though we have filed the criminal petition before this court, Lordship, no order was passed. So we have not mentioned any about any order from this court, Lordship. We took simple adjournment, Lordship. On perusal of the CR, it appears that a proceeding under section 133 CRPC was drawn up on 19/1/23, directing the second party to remove the alleged obstruction or to reply as to why the order should not be made as an absolute. The second party did not submit any reply in this court, rather preferred a revision before the Court of Honorable Additional Session Judge FTC Kathar Silchar. The Honorable Additional Session Judge FTC Kathar Silchar, in judgment dated 6/10/23, White Criminal Revision Number so has affirmed the order dated 19/1/23. That is the first order, Lordship, passed by this court under section 133 CRPC, and further directed the revisionist second party in this case to approach before this court and take part in the proceeding. Complying with the order of the higher court, another order was passed by this court on 30/10/2023. Your Lordship has stated this order, Lordship, directing again the second party to remove the obstruction created by the second party over the schedule mentioned path within 3 days from the date of receipt of copy of this order to show cause as to why the order dated 19/1/2023 should not be made as an absolute on the next day fixed. The said order dated 30/10/2023 is duly received by both parties as per police report dated 4/11/2023. Seen a petition dated 1/11/2023 filed by Sri Ranjit Singh, that is the petitioner of the 133 proceeding, Lordship, and 70 other villagers. Also seen and perused two separate evidence in affidavits submitted by the first party number 2, Sri Samiran Chandra Dhar, resident so and Sri Nirmal Chandra De. So, Lordship, on that day, two affidavit in evidence were filed by the petitioners, Lordship. Heard the first party and also heard learned advocate for the first party at length. From the above and on careful perusal of the CR, including the police report, this court is of the opinion that the second party has intentionally and illegally blocked the public path, which has been used by the second party members and all other local residents since long, and thereby causing inconvenience for the second party members and other local residents for free movement. Moreover, it is also reported that there also exists a Shashan Ghat in the locality, and Kali Puja is also performed in the said Shashan Ghat, and many devotees have to use the said disputed pathway to visit Shashan Ghat and perform puja, etc. Further, the second party did not cooperate with the court's proceedings, though given sufficient opportunities to submit their objection, show cause reply, if any, and prove this case in their favor, but they failed to do so. Therefore, this court is satisfied to believe that there already exists a public path which has been used by the first party and other local inhabitants since long, and the second party members have forcefully and illegally obstructed the said public path by embedding bamboo fencing, etc., and thereby causing nuisance to the people of the locality and making it inconvenient for the first party and other local inhabitants for free movement. In view of the above, the order passed on 19/1/2023 under section 133 CRPC hereby made absolute, and the OC of the concerned police station is directed to remove the obstruction created by the second party members over the schedule mentioned path immediately and report compliance. The case is hereby disposed of after giving the above final order. So inform all concerned accordingly. So my submission is that, Lordship, when we filed an adjournment petition, when the petitioner of the 133 proceeding filed to affidavit in evidence, Lordship, we were not allowed to cross-examine those persons, and we are not even granted any chance to the Lordship until evening of 9th,
No,
Lordship.
but the order says that you are not cooperating in the.
No, Lordship. the party were punished only because we moved the higher forum, Lordship, revisional authority. That is the Lordship version of the 133 proceeding court, Lordship. That we are not able to file our written statement, but we are able to move before the higher forum.
Where is it?
Lord, that is the intention of the order, Lordship, that we move to the higher forum, Lordship. That is in second paragraph, it's stated.
Higher forum means sessions court.
Yes, Lordship. On perusal of the CR, it appears that a proceeding under 133 CRPC was drawn up on 19/1/23, directing the second party to remove the alleged obstruction or to reply. But on 19/1,
Now-
there was no chance
Now, in
given,
the main case, this
Lord.
is an interlocutory appeal.
Lordship.
In the main case,
Main case, your Lordship has already passed order that I annex along with this petition, Lordship, page 15. On Friday, I have satisfied your Lordship that there is a civil dispute pending, and when there is a civil dispute, 133 proceeding is not maintainable, Lordship. And instead, rather, Lordship, the plaintiff of their suit already mentioned in their plaint that we have purchased some property, Lordship, from the other co-sharer, from the pro
no,
forma
this
defendant.
31/2023
That
order is in relation to the same 133
Same
proceeding,
proceeding,
which
Lord.
has now been made absolute
yes, Lordship.
by the impugnant.
19/1 was made absolute, Lordship. First order was passed 19/1/23. Then we moved revisional court, Lordship. The revisional court first stayed the matter. Thereafter, after appearing both the parties, affirmed 19/1/23 and directed both parties to move to the magistrate court, Lordship, trial court. Then we both appeared, and we, after our appearance, the 30/10/23 order was passed, Lordship,
Which has been stayed for the
by
time.
this court, your Lordship.
Now what,
Now my prayer before your Lordship to stay the 19/1/2023 order. That prayer is in my IA, Lordship.
not 19/1, it should be actually 8/11/23.
8/11 as well as 19/1, Lordship. As we, in our petition, we have prayed for quashing the entire proceeding, Lordship. So we prayed in our petition only to stay the 30/10/2023 order. 19/1 was not prayed for staying, Lordship.
In
That-
the
Main petition, there was no prayer for staying
here
19/1.
you have prayed for.
Yes, Lord.
Take steps. We are
Steps we have already taken today, your Lord.
now again in this.
I-
I also you have to take
Lordship.
steps.
Lordship,
The interim, the impugn order which you are, don't take dictation, I'll dictate in paper, I'm just pronouncing
Lordship.
that
Already I have
impugn
obtained
order
the
is state,
order,
here also it is state till returnable date.
Lordship. Your Lordship has list this matter list after 3 weeks. Your Lordship has already directed in main petition.
Whether a fixed date has been given,
No, Lordship. Only after 3,
let me give a fixed date after.
Lord.
Also near the date.
Lord.
20,
20,
2012.
20,
You
Yes.
take steps,
Lord.
go through the order.
Lord. Tomorrow I will take the certified copy, Lordship. Oh, Lordship, they will not accept my application.
I'll pass orders in chamber.
Lord.
The impugned order is stayed. You have to take step within 3 days.
Lord.
Returnable on the date which we have
2012, Lord.
2012.
Both the orders, Lordship, 19/1 and 8/11. I'm deeply obliged.
Regarding leftover matter,
Lordship, I have a criminal appeal 26, today's list, your Lordship. But it has been mentioned several times, Your Honor. We have been left out several times, Your Honor. That's why it may be, that may be fixed, short date may be fixed. Maybe tomorrow, my colleague is also here. Maybe
Tomorrow
tomorrow or on
20 November, Monday.
20th of November next week, Lord. It has been, record will reveal like that, Your Honor. Several times it has been listed,
choose a hearing date.
21.
This matter,
It is in
item number,
Item number 26.
26,
26.
26.
the third.
I'm appellant, Lord. complaint and appeal. It's an appeal against acquittal, Lordship, in an act case.
Written argument have been filed.
Heard,
Both side has filed written argument, Lord.
heard Mr. H.K. Sharma, learned counsel for the appellant. Also heard Mr.
Ardas, Rakul Das.
Ardas, learned counsel for the respondent. This matter could not be taken up for hearing today due to paucity of time. Let this matter be listed again on 21.
Obliged. Please, your lordship, in the item 25, my lord, 10 years imprisonment. I filed the bail application for last pending for last about 2 years, my lord. My learned is saying that already it is over, my lord. The sentence period is over. Still he is not released, my lord.
Sentence period is over.
No,
My
Lordship, they gets 30 days leave each year, Lordship. So he's in jail for 9 years, 8 months, 9 months, Lord. So in my calculation, probably his conviction is over by now.
My lord, he is in custody since 30/12/2014.
No, if your period is over, still your.
That is, it may be, Lordship, otherwise a report may be, jailer may be called for, Lordship. That will suffice and make matter may be fixed on 21st,
This is item number
25.
25.
heard Mr. A.K. Talukdar, learned counsel for the petitioner. Also heard Mr. S.C. Kayal, learned standing counsel
NCB, Lord.
NCB. This
NCB,
is, this is a narcotic case.
narcotic. Lordship, custom case
Standing counsel, central excise
and customs.
and custom. Learned counsel for the petitioner, learned counsel for the appellant has. Suppose the period is over, then what will
Then
happen?
he is
to-
required to be released from the jail, Lordship.
What would happen to the appeal?
Appeal will be influxed. Since he has served
Because
the
the report,
sentence.
as my learned is saying, a report may be put from the jail.
In one case, Lordship, report has been received by court number 21 today. In that case, they have given the details, how many days he has taken leave. And they get 30 days leave each year, Lordship. For 9 years, 360 days. And for 9 months, about another 15
This
days.
matter could not be taken up for hearing due to paucity of time. Stop on this. Learned Mr. S.C. Kayal, learned counsel for the learned standing counsel, central excise and custom, as well as Mr. A.K. Talukdar, learned counsel for the appellant has submitted that the petitioner has been detained behind the bar since
30/12/2014.
30/12/2014, and he was sentenced to
10 years.
10-year RI.
And 1 lakh fine. In
And-
default, 6 months. Verdict.
And
6 months, huh?
Yes, yes.
In default.
sentenced to 10 years imprisonment. And it is submitted that in the meanwhile, he might have completed the detention period as per jail amendment. But otherwise, 10 years have not completed.
Lordship, they get 30 days leave each year. As per jail amendment.
Okay.
So if he calculates that, then probably might have completed sentence.
Because he was sentenced on 24.
Yes.
We are in 23.
Lordship, here it is stated that it will be set off.
Or the period of detention would be set off. Okay. What was the earlier period of detention?
Lordship, the judgment was pronounced in 2018
Let a report be called for
from the jailer. Central.
from the
Central Jail, Guwahati, my lord.
from the superintendent central jail Guwahati regarding the let a detailed report be called for from the superintendent central jail Guwahati regarding the period of detention already undergone by the appellant, namely Sumit Yadav, in connection with which case?
In connection with my lord, then my lord, NTPS case number, my lord. Criminal session in the court, NTPS case number 26 of 2015.
26 of 2015.
My lord, yes, my lord. Additional session number 1, Kamrup.
NDPS case number 26, 2015. Judgment was passed by additional sessions as number 1.
ADG one, Kamrup Metro.
The impugned judgment was passed by the Court of Learned Additional Sessions Judge
Number 1.
number 1.
Number 1.
Kamrup Metro, my lord.
The report be be sent to this court on or before next date, that is
That's it for then next Friday.
next Friday. 7th.
17, I think that's it. Whether it will be
My 21, my lord.
24.
24. Any
No.
Black.